Welcome to Constitutional Chisme,
a law baddie's guide to the legal basics. I'm your host, Stephanie.
And I'm your co-host, Harleigh.
Every week, we will drop an episode that you'll likely cover your first year in law school or some other bar course in your law school journey. Make sure to pay close attention to our podcast because we will drop Easter eggs of what case we plan to drop next week. See if you can guess which one.
This episode is sponsored by Belmonte, a skincare and lifestyle brand centered around the reminder to stay still, grounded, and present. We also want to thank Kaplan Bar Prep for partnering with us. If you or someone you know is planning to use Kaplan for bar prep, be sure to use our code PASSWITHPONZ, that's PASSWITHPONZ, to save an additional $100 off of your course. That $100 off will stack with any other sale that Kaplan is running at the time. This code also gets you 20% off of all Kaplan Bar Prep supplements. And using this code not only saves you money, but it helps support the show and ensures that we can continue to give away free bar prep each testing cycle.
Oh, I do want to say on the supplements, I don't know if you saw my video on TikTok, but I showed my flashcards.
No.
They are beautiful. They're color-coded. Yeah.
Oh, I love a color-coded.
Yes, it's beautiful, and it's not like 5 million things on the back that I will never memorize. And it has a section where you can like write your own notes on the flashcard on the back of it. So, yeah, if you are a flashcard girly, you get 20% off using our code. There's also private tutoring. Did you know that?
No, I knew about the essay graders.
Well, one of our people that won free bar prep from our show, her TikTok handle is Keeve. She was talking to me about her experience with getting the free bar prep, and she has 2 tutors. She gets a bar prep mentor and a tutor. But anyways, we also have a discount code for UWorld, which is Ponzaneli 10. You'll get 10% off. But you can find all of this information in our link tree in the show notes. And our TikTok and Instagram is on there. I will be adding Harleigh's TikTok. She has her own right now. She already went out semi-viral, so heck yeah.
Literally famous.
She literally had a famous person comment, which is crazy.
Yeah, insane. This is like nano influencer. I don't know if you guys have heard of her. Somebody called LEGALLYPONZ. If you guys know who that is, I literally almost passed out. She's such a big name.
I love being dramatic with my boyfriend or anyone and being like, do you not know you're in the presence of a nano influencer? And everyone's like, what is that? And I was like, someone not famous enough to be micro.
I told Bradley when the first video like surpassed 1,000 views, like not a lot is happening, but as soon as it passed 1,000 views, I literally texted him and go, so do you want an autograph now or?
What case are we doing today?
So we are kind of building off of our last episode. And I talked a little bit about how there's more cases that follow Miranda that kind of build on what actually is custodial interrogation. And this is one of those cases. So this is Berkemer versus McCarty. This is a 1984 case. So to give a little bit of background before we even touch on what led up to Berkemer versus McCartney. Not McCartney. Jesse McCartney's not involved in this. It's McCarty. It's McCarty. After the decision was handed down in Miranda, a lot of courts were only applying Miranda warnings to serious offenses. So if you were arrested for, let's say, a felony, that's when you were expected to get your Miranda warnings, but not necessarily for more minor offenses. They were a little more lenient with it.
What are minor offenses you get arrested for?
That could be, say, like a misdemeanor. That could be things like a traffic violation that maybe escalates, something like, something like that, but not getting up to like the felony levels of serious. Okay. So with that kind of backdrop in mind, let's jump into this. So an officer was chilling, doing whatever officers do, sit around and wait to pull people over, and saw the defendant's car weaving through traffic, which who amongst us has not weaved through the traffic?
I haven't, but I do drive a Fiat, so I think that's fair.
There is no weaving when you're in a Fiat. You would get smooshed.
Fiat wouldn't go fast enough, honestly.
No.
Yeah, at least mine doesn't.
So this is where it gets a little less relatable, because then once the defendant got pulled over, they asked him to step out of his car.
Okay.
And that's when the officer noted that he couldn't really stand up. And his speech was a little slurred.
Oh.
Mm.
Oh.
So they were like, King, can you do a little balancing test for us? And he couldn't do it. Womp womp.
Maybe he was really tired.
He's just really sleepy. God. The officer obviously followed up and was like, hey, man, have you been drinking tonight? And the defendant, who had clearly not listened to our podcast and heard us say never talk to the cops, decided to admit that he had had 2 beers and had smoked several joints.
Okay. Why did we have to add the word several?
Why did we have to add the word several? Why did we need to quantify?
Yeah.
But he decided to do that. And not only that, but made sure to specify that he had done that shortly before being arrested.
Okay. At least
Shortly before being stopped. So he was like, I literally just did it, King.
Maybe he was trying to be like, no way it hit yet. Like, it just happened.
You don't understand, man. That's why I was weaving. I was trying to light it. Like, I'm not high yet. Chill. So the officer arrested him. We're all shocked and also surprised, and took him to county jail, where, surprisingly, he was tested and results came back negative for the presence of alcohol.
Oh.
So now that there's that to kind of contend with, the officer goes back to questioning the defendant. And so he's like, have you been drinking tonight? And he's like, I guess barely. And so the officer's like trying to get more details out of him, and he's not really answering any of the questions except for to say, I guess barely. But through all of this, through the stop, the arrest, being taken to the county jail, all of that, at no point was he advised of his Miranda rights.
I thought if you were going to get arrested, you had to give it to him. Isn't that?
Now, see, this is where we get to that important distinction that it was not being applied to non-serious offenses.
Oh, when it turns into a serious offense, is that when you would trigger it? Or if it starts off as a not serious offense, then you don't have to do it at all? Was that the cops' thought process on it?
It's kind of the thought process of, if it's not a definitive felony, cops were not really doing it, and courts were kind of condoning that. And again, it kind of varied from court to court on what was happening, but there wasn't a lot of clarity on, does Miranda apply, period, as soon as you're arrested for anything, or does Miranda only apply when you're arrested for straight up felonies? In this case, driving under the influence or driving while intoxicated are not felony offenses, so the cops didn't think that it was necessary.
Oh, for the listeners, can you say what are felony offenses?
Yeah, so felony offenses are any offense where it's possible to get greater than a year in prison. So obviously this goes to trial. I guess not necessarily obviously. Not all criminal cases go to trial, but this one goes to trial. And he files a motion to suppress, which is essentially when a defendant files a motion that says, hey, some of this evidence is no good for whatever reason. In some way, it violates one of my rights, so it can't be admitted into evidence for my conviction. And so he argues that his pre- and post-arrest statements were a violation of his rights, and therefore they should be suppressed. And the trial court said, nuh-uh.
Yeah.
And obviously, he was convicted. So he goes through the typical appeals process, which can look a little different depending on the state, But all you need to know for this particular case is after you've gone through and gotten a state conviction and you've exhausted all of the appeals that exist on a state level, you can file something called a writ of habeas corpus in the federal court system.
What is habeas corpus? It sounds like a dead body.
Well, actually, it's Latin for show me the body or produce the body, essentially.
Oh, I
And
was close.
yas, okay, Latin queen.
It's giving 3 languages now.
It's giving 3 languages. Oh my god. She's a she's
She's
a polyglot.
trilingual.
She's a polyglot, y'all. So, habeas corpus is a legal procedure invoking
Mhm.
the jurisdiction of a court to review unlawful detention or imprisonment of an individual. So, it's essentially going to the court and saying, for one reason or another, I have been put into prison wrong.
Okay. And can anyone do that, or do you have to exhaust a certain amount of things to be able to bring that in?
Yeah, so you have to exhaust all of your state level appeals before you can file a writ of habeas corpus in federal court.
Okay.
So he brings this petition, the writ of habeas corpus, and the Court of Appeals reversed, holding that, quote, Miranda warnings must be given to all individuals prior to custodial interrogation, whether the offense investigated is a felony or a misdemeanor traffic offense, and that respondents' post-arrest statements, at least, were inadmissible. And then, following that, the Supreme Court granted certiorari to consider 2 particular issues.
What is that? Certiorari.
So, a writ of certiorari is when the Supreme Court says, yes, we are going to hear that case. So they can
Okay.
either grant cert or they can deny cert. In this
Okay.
case, they granted it, and they wanted to basically come to a conclusion on 2 issues. One, whether the Miranda ruling applies to defendants charged with a misdemeanor. And 2,
Mm.
whether an investigative detention is equivalent to Miranda custodial interrogations.
Mm.
So ultimately, the Supreme Court decided that the Miranda rule prohibits the use of testimonial evidence in criminal proceedings that is the product of custodial police interrogation, unless the police properly advise the defendant of his Fifth Amendment rights and the defendant knowingly, intelligently, and voluntarily waives those rights and agrees to talk to the police. And again, the specific circumstances that trigger Miranda safeguards are that custody and interrogation language.
Mm-hmm.
And the Supreme Court basically made clear that custody means formal arrest or the deprivation of freedom to an extent associated with formal arrest. So you need to actually be under arrest
Mm-hmm.
or its basic equivalent. So in this case, the defendant in the Berkemer case was interrogated twice.
Mm-hmm.
So there was the pre-arrest roadside questioning when they asked him if he had been drinking. And then
Mm-hmm.
there was the post-arrest interrogation that occurred at the county jail.
Mm-hmm.
After he had been arrested and taken to the county jail, the defendant was in custody. Obviously, he had been arrested. Being arrested is
Yeah.
kind of the quintessential you are in custody.
Mm-hmm.
So basically, the court had to consider whether to create an exception to Miranda for custodial interrogations that are occurring for minor offenses. So the court's
Mm-hmm.
like, yeah, this is really obvious.
Mm-hmm.
Okay. No question about it. This guy was in custody and you were interrogating him.
Yeah.
But is it different if it's not a felony?
Mm-hmm.
And the Supreme Court said, no, it's not any different. And specifically, they said that to create such an exception would sacrifice the certainty and clarity of the Miranda rule. So this is where the Supreme Court kind of drew the line and said that pre-arrest interrogation when they were still by the car,
Mm-hmm.
was that a custodial interrogation for the purposes of Miranda? So we've established that this one over here is. What about
Yeah.
this first one?
Where they weren't, they had
Where
no
they're just
idea,
chit-chatting on the side
right?
of the road.
Yeah.
So here, the court says, no.
Mm,
Roadside questioning of a motorist who's detained pursuant to just this routine traffic stop is not custody for the
mhm,
purposes of Miranda. So, although you're technically stopped, you
mhm.
can't exactly just run from the police.
Yeah.
It doesn't have the same pressure as, say, an interrogation room.
Mhm,
And specifically, the court said, quote, although an ordinary traffic stop curtails the freedom of action of the detained motorist and imposes some pressures on the detainee to answer questions,
mhm.
such pressures do not sufficiently impair the detainee's exercise of his privilege against self incrimination to require that he be warned of his constitutional rights. And specifically, the court put a lot of emphasis on the fact that traffic stops are usually very, very short and
Mhm,
that most people expect to be given a citation and that's about it. And then they're
mhm,
just going to go about their merry way.
mhm.
But once it escalates past that point,
Uh-huh.
if something happens during the traffic stop that requires a person to be detained beyond that, that will render him, quote unquote, in custody, which will, quote, entitle him to the full panoply of protections prescribed by Miranda.
Okay. So would everything said before then be admitted?
Yes. So they said everything that happened during the roadside interrogation,
Mhm,
perfectly acceptable. He did not need to be advised of his Miranda rights yet. But everything that happened after that, so the second round of questioning, the
mhm.
police had to read him his Miranda rights, even though it did not rise to the level of a felony. Once he was in custody, all questioning had to stop until he'd been given the full Miranda warning and had given a waiver of that.
So had he not said anything about smoking and drinking when he was originally pulled over and when he was arrested, and then he had said something, it wouldn't have been admitted. But because he said it earlier, that information is going to be brought in, right?
That information can still be brought in and weighed by whoever the fact finder may be it a jury or a judge. They get to weigh that evidence in determining his guilt.
Okay. Did he end up being guilty?
So, yes, the Supreme Court basically said that the second half of his interrogation was, in fact, inadmissible, but because that first round of statements was still admissible, his conviction was upheld ultimately. But it did
Okay.
create a very clear distinction and specifically created two significant differences between interrogation of a person who's actually in custody and that of people who are just simply being detained. So the first is the length of time that you're detained.
Mhm.
So when an investigative detention is brief and culminates at the end with just the issue of a citation,
Uh-huh.
that is just a detention. That is not custody.
Okay.
And then, second, the circumstances attendant to roadside detention are substantially less coercive and compulsive than those of a traditional custodial interrogation. So, same thing, you have a little bit more autonomy when you're just sitting in your car answering a few questions than you would probably feel if you were in handcuffs sitting in an interrogation room being asked questions.
Yeah.
So those are the two big differences, the length of time and the pressure that the court says that's why we have to draw a distinction between when Miranda warnings have to be given. It's not about the severity of the offense that you're being arrested for. It's about the amount of time that you're being confined and the pressure that's placed on you to answer questions from the police. That's what triggers Miranda.
Okay. That was good.
The court also put a little bit of emphasis on the fact that, like, during traffic stops,
Mm-hmm.
you're also out in public.
Mm-hmm.
So you're also not behind the four walls of a police station where no one can see what's happening.
Mm-hmm.
You're on a public road, meaning that everything that the officers do is exposed to the public. And therefore, that's going to curtail a lot of what Miranda is meant to protect against, as in, like, you know, using violence to sort of force confessions, kind of like what we talked about last time. Stuff
Mm-hmm.
like that is less likely to happen when the police know there are or could be eyes on them. So to kind of sum up everything from Berkemer, there were, like I
Mm-hmm.
said, there were two issues that really were brought before the court in Berkemer. And the first one is, did the highway patrol err in failing to give a Miranda warning to McCarty before he made incriminating statements at the station house? And then two, did the highway patrol err in failing to give a Miranda warning to McCarty when he was detained pursuant to that traffic stop and under suspicion for the misdemeanor of driving under the influence? So the court held yes and no. Arrestees in custody and under suspicion for a misdemeanor traffic offense must be informed of their constitutional rights, or subsequent statements are inadmissible. But prior to being placed under arrest and going into custody, an officer is not required to inform an individual of their Miranda rights. So the explicit rule here is Miranda applies whenever interrogation occurs in custody. Routine traffic stops are not custody, absent
Mm-hmm.
formal arrest or an equivalent restraint.
Okay.
And that's Berkemer versus McCarty.
All right. Well, as you guys know, we will have a link in our bio that you can click. You'll find this if wherever you're using to listen to the podcast, you can find it in the show notes. And that'll have all the information on Kaplan Bar Prep, the discount codes, our social media, our Patreon. All of that information will be located in the link in our show notes. If you follow us on Instagram, you will also be able to find our link. And yeah, we'll see you later.
Bye.
Bye.